Good afternoon, everyone. My name is Daniel Gvertz. I'm a partner here at Tully Rinke. I and my associate Jillian Falt will go through our presentation today regarding grandparents' rights and filing for custody and visitation, which is always a fraught subject in the family court. We generally don't get to this place without a lot of, frankly, no better way to put it, a lot of devastation going on. It's not a simple procedure. It's not an easy procedure, and it's not anything that anybody would ever choose to go through. We're going to go through a lot of the factors that go into making a petition, prosecuting a petition, but also we'll try to provide some insight into, when it really is necessary and when it really is something that you want to go through with. I hope you get the information that you need from here. And like Brittany said, if you have any questions, you can put them into the chat and we'll endeavor to answer all of them.
All right, so we wanted to start off going into the historical background of grandparent visitation rights in the state of New York. And grandparent visitation rights were created in 1966 by the New York State Legislature. The specific statute was Section 72 of Domestic Relations Law, which initially permitted one or both of the grandparents to sue when one of the parents had died, and then the court had to determine whether visitation would be in one of the grandparents or both of the grandparents or in the child's best interest. And then in 1975, the statute DRL Section 72 was expanded to allow grandparents to sue even if a parent had not died, provided they could show that equity would see fit to intervene. In June 2003, the legislature further amended DRL Section 72 to allow grandparents to seek custody of grandchildren when extraordinary circumstances dictated the need to give custody of a child to a grandparent. This amendment didn't change the existing custody standard, but rather it seemed to merely have codified longstanding case law in New York that allows any third parties, not just grandparents, to seek custody in a court proceeding in limited extraordinary circumstances such as parental surrender, abandonment, abuse, or prolonged periods when the child is separated from the parent and bonds to another caretaking adult.
That last part, generally, you don't get a lot of specific right line definitions when we're talking about family law, but that last part generally will apply to periods of time longer than a year. So that would be where the child is in the custody and care of a grandparent or any other non-biological parent for a year of continuous time or longer.
And we wanted to bring up, after this landmark decision by the Supreme Court, and the reason why we're bringing up parental rights is because many times in grandparent visitation actions, of course, you see grandparent visitation rights conflicting with parental rights. And the United States Supreme Court has held a fundamental right that parents have to make decisions concerning the care, custody, and control of their children. And this decision set a precedent that state courts must consider, ensuring that parental rights are not infringed on without compelling justification. This ruling also means that while grandparents can seek visitation, they must do so in a manner that respects the parent's primary role and authority within the family unit. And then within New York State commencing the action, of course, the legal process for grandparents seeking custody or visitation involves several steps, and it begins with filing a petition in the family court. The petition must outline the grounds for visitation and provide supporting evidence. The evidence can include affidavits, witness statements, documentation of the grandparent's relationship with the child, and the parent's circumstances, whatever they currently are or what led up to filing the petition. After filing the petition, a court hearing is scheduled where both parties present their arguments.
It's important in the petition to outline not just the circumstances that led up to where you are, but also, and the number one thing, and I'm sure we'll get into this more, the number one hurdle that grandparents have in filing these kinds of petitions generally turns out to be standing, the ability to even be heard in court. And that's what we were talking about earlier in terms of, one of the biological parents being deceased or other special circumstances being shown. The petition is where you really have to outline, if you don't have obvious standing, it's where you have to really outline why it is you believe the court has the ability to hear your petition. And that's what standing means. Standing is what gives the court the ability to hear your petition. In order to have standing, you have to show, the extraordinary circumstances that we discussed earlier, or a situation. It's kind of the vaguest term I've heard in the law, really, a situation where equity would see fit to intervene. I don't have a definition for most of the words in that sentence, but that's where you have to focus most of your energy on in filing these petitions.
And then expanding on what Daniel just said, to be successful, a grandparent visitation petition is written as a two-step process. Step one, of course, the first step is to show that that grandparent has standing. So the first step is to show us that the grandparent has standings to petition to the court. Standing means that the court recognizes that a person has met the criteria to go forward with an action. Without standing, the petition can and most likely will be dismissed. There's a few ways to show standing. Circling back to what we said, if one of the parents is deceased, then a grandparent automatically has standing and the case can move forward. If the grandparent has an existing good relationship with the grandchild, or if despite your efforts to have a positive relationship with your grandchild, the natural parent has blocked your efforts, you now have standing to file this petition. And then the next slide just shows an example of what a grandparent visitation petition would look like. And then step two, only after you've shown standing and only after you've shown with proof to support that you have standing, the second step is to show that it's in the best interest of the child to have visitation with you. Some examples and factors for best interest of the child that courts include when making their determination are the reasons for the parent's objection to visitation, the child's wishes, the previous relationship with the grandparent that they had with the child, the benefit to the child by visiting with the grandparent, and the grandparent's feelings towards the other parent.
And these are things that can generally be shown in, this is where you have your pictures and things like that, and messages that were sent, and, experiences that you've shared with your grandchildren, and those types of, that's the type of evidence that we're looking for here. Some of the things that we often don't know or can't know until we get into this part of the process are the reasons for the parent objections to visitation. Courts have been pretty clear that it has to be more than just an acrimonious relationship between the natural parents and the grandparents. There has to be something a bit more than that. But in just your general everyday life, there's no requirement that somebody gives you that information. So it's often hard. This is often where we get to the root of the problem, and we've already started the legal process. So it's a tough slope to get down. But these are things that you wind up finding out during the legal process sometimes.
And then expanding on that, additionally, for grandparents and other non-parents to become legal custodians of children, there must either be consent or the existence of an extraordinary circumstance. Some examples of extraordinary circumstances are persistent neglect, abandonment, an extended disruption of custody, or similar circumstances. When a grandchild resides in the grandparent's home for 2 or more years, that is deemed an extended disruption of custody and will be considered an extraordinary circumstance. Procedurally, the court will first conduct a hearing to find out whether the extraordinary circumstances exist. Only after the family court has determined that an extraordinary circumstance exists will there be a trial to determine whether custody is in the child's best interest. And then the role of a family law attorney in grandparent visitation actions like this. So an experienced family law attorney can help prepare and file the necessary paperwork, such as the visitation petition, gather and present evidence supporting their case, and represent them in court hearings. In addition, a family law attorney can assist with the negotiating agreements with the child's parents, mediating disputes, and ensuring that the grandparents' rights are not infringed upon. By enlisting the help of a knowledgeable attorney, grandparents can increase their chances of successfully asserting their rights, maintaining strong bonds with their grandchildren, and achieving a favorable outcome for all parties involved. And then to schedule an initial consultation with a member of our experienced team, our team can be reached 24 hours a day, 7 days a week, and we have their contact information on this slide to book a consultation. You're also able to book a consultation on the website.
So before we get into questions, you know, a lot of times we have situations where, and I actually think we do have a question about this, but a lot of times we do have situations where, there's an ongoing custody case between, the biological mother and father. And during that time, the grandparent is not getting the chance to have visitation. And when we talk about, when we talked about earlier, the best interest of the child and the criteria for standing, just not getting your chance to have visitation is not necessarily what you need in order to, to make your way into court. And just in general, in my experience, what I've seen is a lot of times, grandparents will try to file their own separate petition during the pendency of a custody petition in family court. And you wind up just sort of sitting on the back and just waiting for the custody dispute between the mother and the father to settle before ever one time being heard. And you wind up wasting a lot of time and a lot of heartache trying to make your way into this when they're not the court's not really going to address your concerns until after whatever's settled between the biological mother and father. So a lot of times, although it might be hard and it might be very taxing on you emotionally, it is better to wait in situations like that. And then, just to make sure to sort of hit on what we already spoke about, it's important to make sure that you're not jumping into court just because you're not having the chance to see your grandchildren. You want to show the court that you've exercised every possible way to have time with your grandchildren despite the existence of whatever acrimony is between you and the natural born parents, because until you're able to show that, courts are not likely to uh, push into the rights of the parents to extend rights to grandparents. And then I do think we had some questions from before. So the first one just came in here. What language needs to be put in an order for grandparents to make decisions when they get temporary or permanent custody? So if we're talking about an order entered by a court, so we've already sort of established, standing and best interest of the child, and we're at the stage where we're making an order, either it's by agreement or, the court drafting it after, testimony at trial. If we have an order, if the grandparents are given legal custody, and that's legal custody is who has the ability to make decisions on behalf of the children. That's where you hear terms like joint or sole legal custody. If a grandparent is given joint or sole legal custody over the child or the children, that's all that needs to be in order for that grandparent to make decisions on behalf of the child. So, registering them in school, medical decisions, things like that. If we're talking about a temporary guardianship petition, that's not the same thing as custody, but that's something that's crafted by the Office of Children and Family Services, and they generally will go over with you what it is you're allowed to do if a child is being temporarily placed with you. But if we're talking about a custody order and the grandparent would like to make decisions, then you have to make sure that it says, the grandparent has either sole legal custody or joint legal custody with, one of the other biological parents. And then another question comes in: what would be a valid reason for a parent to withhold visitation? And that is not not a simple question. And that sort of gets into the crux of what I was trying to talk about earlier. A lot of times, and this happens to everybody. A lot of times, you have a falling out, you have a fight, you have a disagreement, and even though it's between you and your child, or you and your your in-law, it splashes back on the children, right? And the children are the ones made to suffer by, we're not going to go see you anymore, we're not going to let you around the house anymore, and that's definitely a heartbreaking situation to be in. But the courts have made very clear, and what Ms. Falt was outlining in the case law that she presented, the courts made very clear that the will of the parents is not lightly subverted. And what that means is we give a lot of credence to the natural born parents when they're making decisions on behalf of the children, because that is their right and their responsibility. But we do live in a new age, right? These children at younger and younger ages have cell phones, and they have the ability to communicate. And I'm not saying that, you should sneak around and go over and above, a parent's objections, but if a child of, reasonable decision-making age who has a cell phone wants to communicate with you, they have the ability to do that. So you can always, try to communicate in that way. But in terms of what a valid reason to withhold visitation, it's not an easy question to answer. It has to be, the courts have said, more than just acrimony, more than just we disagree, more than just I don't like you. So it could be things like, refusing to ever enforce safety precautions or other rules on behalf of the children that the parents normally want to, refuse undermining the parents position on important things that are for the safety and benefit of the children, things like that. I've seen as valid reasons. Another one that I have seen, and it feels like an accusation when I say this, but I don't mean it that way. In a situation where one parent has all of the visitation with the child, and for whatever reason the other parent only has supervised visitation, or very limited visitation, if a judge allows for the parent of that parent to have their own separate visitation, that visitation can't be used as an end around to get more visitation for the parent who has limited time. And it sounds a little convoluted when I explain it that way, but what I mean is, if one parent has very limited time and their parent wants, to create more time for them, they can't use grandparent time as parent time. And when judges see that, they will agree to withhold visitation from the grandparents on the basis of the fear that the grandparent is using their own time to subvert a court order. So the next question is about filing for a modification or reporting noncompliance. If you have noncompliance with a court order, you can go ahead and file what's called a violation petition with the family court. We can help you with that as well. We would outline the terms of the order that are not being complied with, and show what it is that should have been happening, and make requests that go for correcting that behavior. And if that's a further modification of the order, or if it's request for fees, and sometimes it's just a slap on the wrist, and the judge looks everyone in the eyes and says, you'd better start following the order. Sometimes it's as simple as that. In terms of a modification, any modification of an existing court order has to start with, first of all, everything that we discussed here, if we're talking about grandparent visitation, but also a substantial change in circumstances from the last time that a court order was entered. So something that shows, what's different today than it was, 6 months ago, 2 years ago, whenever it was the last order was entered. We have to show what's different today. So I think, and then beyond that, we have to go into all of the other details if we're talking about grandparent visitation. So the next question comes in when you have very little rights established because the son and daughter-in-law make you look unsafe on purpose? So that's a very factually specific question, and I'll try to take it in parts. When the son and daughter-in-law try to make you look unsafe on purpose, that requires sort of an examination into what exactly the allegations are. And what I always try to stress when clients call in is, what is it that we're able to prove? So if they allege that you are unsafe with the children and you disagree, right? Are and you're saying they try to make you look unsafe on purpose. Well, how is it that they are doing that? Right now, you're getting into, when you're talking about something like that, you're getting into the operation of somebody else's head, right? We don't know what's going on in somebody else's head. We might be able to infer, we might be able to conclude, but we can't. When we're talking about a court of law, we can't testify about those things. So we need proof of what is happening. Now, if you want to say, well, they think that what I'm doing is unsafe, but what I'm actually doing is something else entirely, well, then we can provide proof of those things. But it falls into, the one of the earlier questions is, what would be a valid reason for a parent to withhold visitation? And that's, it's a very amorphous thing. It's not an easy, situation to answer. And we can try to navigate through that with you, when you call in for a consultation, so that we can talk about exactly what's going on. And a lot of times, the overarching message that I hope comes through here, a lot of times we're able to put solutions to these issues without the need of going to court, without the need of filing a petition, right? I start every single grandparents' rights case with a letter, on behalf of the grandparent to the parents, because nobody should want to find themselves in family court. Once you're there, there's already been a failure of communication and a failure of cooler heads prevailing. So a letter from on behalf of the grandparents to the parents, just to try and figure out what the issue is and what can we do to create a situation where everybody is comfortable with visitation. And just opening up that dialogue a lot of times can really solve the issue. And sometimes it's not, it's not possible for families to do that. I know I know how families are. I know how hard these things can get when you're as close to the issues as you are. So sometimes it really is necessary to call an attorney and ask an attorney, hey, can you find out why it is they don't want me around their grandchildren? And sometimes it's something that you didn't realize that you didn't know was a problem. It's a miscommunication. It's any number of things. But it's important to know that if you can clear these issues up, you can get to, the situation that you're looking for. And maybe you never needed, a family court petition at all. Maybe you just needed a mediator to step in and try to help figure out what the situation was, and how we could make everyone more comfortable. The next question comes in: visitation with granddaughter due to estrangement with my son, who was divorced from the child's mother. And that's kind of similar to the situation that I was talking about earlier, it sounds like, where the son does not have a lot of time with the grandchild. And so the grandparent is trying to get their own time. And that is something that is possible. It's easiest when we can work on something like that outside of court, and we can just come to an arrangement with the child's mother. But even if that's not possible, courts can and will, as long as you can show that you had a pre-existing relationship with the child, and we can establish the extraordinary circumstances as discussed earlier, as long as we can show those things, and courts will order some kind of visitation for the grandparent. That's the situation I was talking about, though, where the court will be leery of, is the grandparent using that time to create more time with the son who, for whatever reason, is estranged from the grandchild? That's the concern of the court, and it's not an accusation. It's just that's the number one concern that courts have in situations like that. So you'd have to also show, it would be important to show your earnestness in, this is my time with my grandchild and not, my son's time just through me. And that looks like all of the questions that we have right now. There might be some more brewing, and if there are, and if you have very specific questions that are, specific to your case, we can't really answer them here. And you can absolutely reach out. I'm sure we'll put the contact information back up. There it is. You can reach out and schedule a consultation with myself or one of the other family law attorneys here at Tully Renke, where we can help you answer the questions. You don't have to, like I said, you don't have to file a petition just because you spoke with an attorney. Sometimes it's worth it just to get, some background on your case and have a conversation about what it is that you can do and see if it's possible to fix the issues without resorting to the legal process. I don't know how many of you have been to family court. It is not a good place. It is not a place where you go for hurt and problems in your family to be solved. It's not that for you. What it is a place where a judge makes a decision on the future of your family. If that is something that you need, it's something that we're obviously able to provide and provide help with. But many, many, many times what you really need is, just to open up the lines of communication and to try and figure out what it is that went wrong. So if you have questions that are specific to your case, you can give us a call, schedule a consultation. The cost of a consultation is $150 for up to an hour of our time. And we will, go over your case with you, let you know what we believe all of your options to be. And we will always be honest with you. We're not going to try and take your money for a retainer and then turn around and say, well, you really don't have a case. We'll let you know at the consultation if, what you've presented is more of a disagreement or more of something that, can be actionable in a family court. And with that, I believe we are all set, unless any questions come in the next couple of seconds here. But thank you all for taking the time today. I appreciate it, and I look forward to hearing from anybody who would like a consultation.